AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Welcome to You and the Law here on AM 650. Joining me in studio, David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver. David and Ian, welcome back to the program.
Glad to be here, Sterling.
Ian, good to see you too.
Thanks, Sterling. Good to see you.
Tell us a little bit about Hobbs Giroday, sir.
Hobbs Giroday is a little law firm downtown Vancouver, right across from the courthouse. And one of our primary areas of practice is estate litigation and probate matters.
Okay, so you deal with wills and estates, David, but you don't spend any time as a practice drawing up wills. Your work comes well after that stage in a person's life, correct?
That's correct. We don't draft the wills, but we review wills that have been created. Sometimes there's disputes connected to wills or issues of construction, problems arising relating to wills, and that's what we deal with.
Right. Ian, how long has the firm been around?
David and I have worked together on and off for 26 years, but our firm, in its present emanation, is about 8.5 years old.
Interesting. David, when people have disputes over estates and the details surrounding estates, what are the most common areas that people really get their backs up and argue and come to legal blows over?
Well, usually it starts with a phone call and then a meeting, and typically we're meeting with people who are beneficiaries of someone's estate. They're either named in the will, or if there's no will, then they are a close relative of the deceased and wondering whether they have an interest in that estate. And there's generally a concern about that beneficial interest, about the administration of the estate. Basically, what are my rights, and am I being treated fairly? And we meet with people and explore those types of questions.
Ian Giroday, you said your company, your wills and estates litigators. That implies a lot of time spent in court. Do most of these disputes involving wills and estates end up in court, Ian, or does the majority of them get settled outside of court prior to that last hurrah in the courtroom?
Right. Well, there's really sort of two elements to our practice in this area, Sterling. One is the administration of estates. And in that regard, we're helping administrators or executors who are charged with or want to propound a will or administer an estate where there's no will. We help them file documents in the court.
Okay.
That usually doesn't involve disputes.
Sure, because there are processes you have to go through.
Exactly.
Okay.
You have to prove the will or get appointed as executor or administrator through the court process, through a court order. And then in terms of the disputes around estates, we typically would commence legal action, and on rare occasions we may end up in a trial if the parties can't come to some somewhat amicable resolution by way of settlement. But the vast majority of the cases are settled either through an informal settlement negotiation between counsel or the parties, or through a formal mediation process.
David, I've heard from other lawyers that when you're selecting a lawyer for whatever purpose, one of the questions you should be very upfront about when you're interviewing a prospective lawyer is, do you ever go to court? And if that attorney replies, no, I never do, you should probably take a look at another lawyer. I mean, now this is generally a kind of a sweeping statement, but you guys, and Ian just said, we commence legal action. The implication being, if we don't get this done, then by gosh, we will go to court. So again, just the fact that you're ready to go to court and will, if necessary, that makes a difference when people go to select you, correct?
Well, that's correct. I mean, it is an option, and if you're not going to preserve all your options for resolving your problem, then you're giving away something.
I think so.
And the other issue is time. Your lengthiest way of resolving your problem is the full court process and the trial. and you should start the process, get the trial date set, and say, okay, that's one option. I may end up resolving this problem this way, but at least I've got it set up. I'm ready to go, and I'll go that way if I have to.
Right.
If it gets resolved some other way, well, all the better. And you're always weighing the court process and the trial and the outcome and all those risks and issues with other alternative solutions and trying to make a choice. And it varies from client to client because your risk tolerance may differ from person to person,
right,
depending on age or financial means or other issues. And so not everybody makes the same choice faced with the same circumstances.
And if I might add something to that, Sterling, there's one of the other important reasons to commence litigation early on in the solicitor and client relationship is because there's limitation periods. That are applicable.
You have only so much time within which to get something started.
Exactly, and I know we've talked about this before, but for example, with respect to a wills variation claim, there's a very short limitation period. A person who wants to bring a wills variation claim must do so within 6 months of the grant of probate.
And a wills variation simply means you want to change one or more of the clauses or items in a will.
Right, you're saying I am either a spouse or child, because those are of the will maker.
Right.
Because those are the only two groups of people who can bring a wills variation claim or have standing to bring a claim. And you're saying I wasn't treated fairly under the will, and I'm asking the court to rectify that situation.
Oh.
The other aspect about commencing legal action early is there's very good reason and incentive to settle when you've got an ultimate end game. So long as there's no litigation commenced,
there's no threat.
There's no feet to the fire, so to speak.
Right, exactly. Right. So again, and one would, I think, in most cases, David, want to resolve before going to court and incurring that additional level of expense, and I'm sure some emotional trauma attached to it as well.
Yeah, I mean, there's a cost physically, mentally, financially, and otherwise to court process. It's another way of stressing yourself out in life, and nobody needs stress. But if you're going to solve problems, you have to do it in a reasoned manner, and to do that, you have to have real information, you have to have proper advice, and you have to properly analyze things to determine what the outcome is going to be, and that's what we help people do.
Well, one of the things, Ian, that you said at Hobbs Giroday that you do is you work with and provide assistance to administrators and executors. What's the difference between an executor and an administrator?
Not much.
Okay.
An executor is appointed under a will. So, all wills will have a clause saying I nominate and appoint so-and-so as to be my executor and trustee of my will.
Okay.
An administrator arises where the person who's applying to administer the will is not named as an executor under the will, in which case that's called you're applying for an administration with will annexed.
Okay.
And that might arise where the named executor or executors, alternate executors, have predeceased the will maker.
Okay, sure.
Or they've decided they don't want to take the task on. Perhaps the will's quite old and the executors are now quite old and don't feel up to doing it.
So does that happen? I'll let you finish, but does that happen from time to time where someone is asked to be an executor and many years later the actual assignment comes up, the person who asked you has passed away, and now but this is so many years after you agreed to be the executor, and now you just don't feel up to the task. Can you bow out gracefully and legally? Is that possible?
You can. It's called, you can renounce. And the one issue that you have to deal with, so to speak, in renouncing is you cannot intermeddle in the estate. In other words, you can't take any significant steps to administer the estate.
Once you're out, you're out.
Yes, and if you want to get out, you better not do things which by putting a foot in the door.
Oh, okay.
Yeah, I mean, something as simple as arranging the disposal of the cremation of the body or something like that. You're now starting to administer that estate. So if you take a step, and then you say, I don't want to be this anymore, you'll be faced with a legal principle, which is intermeddling, and when you intermeddle, you start administering, you can't renounce. So it's very problematic to stick your toe in the water and then try to not jump in and to back away.
You ever get calls, David, from people who just out of the blue? I heard you guys on the radio on 650, and yesterday my brother-in-law asked me to be his executor. I don't want to be his executor. Am I compelled? Can I just say no thanks? What do you tell these people when they balk at the notion of even being an executor?
Well, we do get calls all the time, and I probably have had a call like that. But practically speaking, if someone asks you to be the executor, I think on an emotional level, people feel honored that the respect being shared, that you would look after someone's affairs. But on a practical level, it's a job. It's a lot of work. You may have to deal with a lot of people who may be unhappy when the time comes to administer this estate, either against you or amongst themselves. And so it can be a very difficult and onerous job. It can go on for years. The pay is not great for that job.
Is there any pay at all?
Yeah, there's a fee for executors, and the will can create a circumstance where the fee is greater than what it would otherwise be.
Okay.
But executors get fees, and there can be a dispute about what that fee should be. And this relates to at the end of the administration with the passing of accounts and that sort of thing. But I think our discussion, one of the things it does raise is the idea that you want to look at your will every few years and make sure that the content of it is appropriate for your present circumstances, what you were thinking 5 or 10 years ago.
Right.
As to who's going to be my executor or how am I going to distribute my estate. Your thinking or the players or the attitudes or the circumstances may have changed, and you may need to reflect on what you want to happen.
Yeah, I want to come back to that in a second, but Ian, you were in the middle of the description of the difference between an executor and an administrator, and I kind of took a side turn there because I wanted to find out more details about whether or not if somebody says, I want you to be my executor, you are legally bound by that wish, and evidently you're not. What about an administrator?
Right. So you can be, as I mentioned earlier, you can be an administrator with will annexed where you're not named in the will as the executor.
Right.
You can also be an administrator where you're not, where no one's appointed. In other words, there's no will. So you're an administrator on an intestacy. But you're still subject to the court's governance, and you have to apply to the probate registry in the same fashion and seek to be appointed as the administrator.
Okay.
And the reason for that, of course, is the court wants some control over the behavior of executors and administrators, make sure that they're doing their job appropriately because they are trustees who have a very important duty to represent the interests as expressed in the will or in the law without in an intestacy, and to act in the best interests of the beneficiaries.
Well, now you've said in the past that when one is appointed or asked to be appointed, that frequently Hobbs Giroday provides information and assistance to these individuals, either administrators or executors. Is there a primer that one can avail oneself of online, or once you assume or agree to be someone's executor, then do you need to see lawyers like Hobbs Giroday just to get yourself up to speed on what you've just said yes to?
Well, I'm sure with the wonders of the internet, there's lots of information about the administration of estates, and of course you'd have to look at British Columbia if you're in British Columbia, and be careful not to be looking at some other jurisdiction.
Good point. You bet.
But leaving that issue aside, it's like everything. There can be issues that you need some advice or some help with. That, it's the old story of what looks simple may not be as simple as it looks.
Right.
And the process generally, I think, is relatively simple. There are forms to be filled out. There's notices to be given. There's things to be done with the court registry. But the devil's in the detail. And in any given estate, there can be issues that having some advice and help with would maybe prevent a problem downstream.
Okay. I need to take a quick break here. Our guests, David Hobbs and Ian Giroday from Hobbs Giroday on this edition of You and the Law here on AM 650. Lots more still ahead. Stay with us.
This is You and the Law. There's more of the show still ahead on AM 650.